Good morning, everyone. Welcome to our TUPE Club webinar today. This is a back to basics session and we're focusing on the key issue of information and consultation. I'm Siobhan Bishop and a Principal Associate in the Employment, Labour and Equalities team here at Gowling WLG. And I'm joined today by Rebecca Jones, who's a Principal Associate in our team, and Jasmine Coyne, an Associate with us. So we're also joined by KJ Clark, who's here to help with any technical issues that can arise. So if you have any questions on that, please contact her through the chat button on the webinar. So today, as I said, it's a back to basics session, but we're going to drill down and focus on this one key area of information and consultation, because that's really key to ensuring that we have a smooth transfer and to avoid some key liabilities. So here's the agenda for today. First of all, Rebecca will look at the key issue of preparing and planning and why that's such an important stage before the process even begins. Jasmine will drill down into the actual detail on sharing and obtaining employee information. And then we'll look at measures and how you can identify them and what that actually means if you have identified any measures. The actual process, looking at the legal and practical aspects of managing that process, and finally looking at avoiding liabilities, because this really is an expensive area if there is a claim. So as you can see, we've got a full agenda today. It's going to be quite a lot to get through, and we're going to focus on that rather than having any questions and answers at the end. But there will be a full recording of this webinar, plus the slides and a transcript on the website for you to refer back to after the webinar. So I just want to have a quick word about the definitions we're going to use for anyone who's new to TUPE, as this is a back to basics session. So the information and consultation process will apply to both a business sale and to an outsourcing situation or a service provision change. And for the parties that are involved, for the employers that are involved, we're going to refer to them as transferor and transferee. So the transferor is effectively the existing employer, the employer before the TUPE transfer happens. And that's sometimes also called the outgoing employer because they're effectively replaced by the new employer. And that's going to be the transferee. So the transferee is a new employer who's taking over the employees, and they're also sometimes called the incoming employer. So I hope that clears that terminology up for us. I'm going to hand over straight away now to Rebecca to deal with the preparation and planning of the process.
Thank you, Siobhan. Well, the focus of our session today, as Siobhan just said, is going to be on the information and consultation process. So what is it? When does it apply? What are the requirements? And how can you make sure that it runs smoothly? And we'll answer each of those questions as we go through the webinar this morning. But before we get stuck into that, if there's one message that I really want you to take away from today, it's that planning and preparation is key. So the better your planning and preparation, then the smoother we expect the consultation process to run. And when we're talking about planning and preparation, we mean slightly different things depending on whether you are a transferor, so that's the outgoing employer, or the transferee, which is the new employer. Now, for the most part, it's the transferor who has the greater responsibility in connection with the duty to inform and consult. And Jasmine's going to come on to explain the requirements for that process and what it looks like in practice a little bit later on. But before we get to that, we're going to have a quick look at some of the initial preparatory steps that need to be taken to make sure that the process runs as smoothly as possible. So there are two preliminary steps that need to be taken by the parties to prepare for the consultation process. And if you can bear with me, I'm going to work backwards for a moment, because the first question that we're often asked when an employer is ready to start planning TUPE consultation is basically, how much time should we allow? And spoiler alert, but you're going to find out from Jasmine later in the session that the answer is that it depends on the measures which are envisaged. In short, the duty to consult under TUPE is triggered where the transferor or the transferee envisage taking measures which will affect the employees in connection with the transfer. And the transferor must ensure that adequate time is given to allow consultation about those measures. So sorry, Jasmine, I hope I didn't steal too much of your thunder there. Now, we're going to take a look at the concept of measures in a bit of detail shortly. But before we look at measures, we need to take another step backwards, because from a transferee's perspective, they're going to need to know all about the employees who are coming across and the arrangements that apply to them, so that they can identify what, if anything, might change for the employees, and therefore what are the measures that they envisage. So in a moment, I'll hand over to Jasmine, and she's going to have a look at the arrangements for sharing employee information. And then once we've done that, we'll then move on to look at identifying measures before we then take a closer look at the nuts and bolts of the consultation process. And before we move on to that, I just had one more slide I wanted to share with you while we're on the subject of preparation and planning, and here it is. So the slide sets out what I see as the 4 key pillars to effective preparation and planning for a TUPE consultation process. So the first pillar there is to understand the obligations under TUPE. So again, who do you need to consult, what about, how and when? And that's essentially the legal bit, which Jasmine's going to come on to look at a little bit later. And I promise I'll try and avoid any further spoilers on that, Jasmine. And then the second and third pillars, which are at the bottom of the diagram there, are what I consider the practical steps for the transferor to carry out. And the first of those is to prepare a timeline, setting out the steps that it will take and an outline of the meetings that it plans to hold as it goes through the consultation process. Now, of course, the transferor can draw up a rough timeline for the process early on, but it does need to make sure that it reviews that once details of the measures are known to make sure that adequate time for consultation has been factored in. And in the bottom right-hand corner, alongside the timeline, is the need to prepare a pack of documents that are going to be needed at each stage of the consultation process. So again, Jasmine will talk through the essential documents that we want to see, but we're basically talking about things like scripting an initial briefing to employees, preparing an information letter about the transfer, and it's a good idea to get a Q&A ready that can then be updated throughout the process. And then the final pillar in the top right-hand corner, I've just included a note about communicating with the transferee. So the extent to which the transferee is involved in the process is going to depend very much on the nature of the transfer. But where there is a working relationship between the parties, having that open communication will generally make for a smoother transfer and consultation process. And I think that leads us neatly into the next topic. So I'll hand over to Jasmine, who's going to take a look at sharing and obtaining of employee information.
Thanks, Rebecca, and good morning, everyone. Hopefully, as you know, TUPE stands for the Transfer of Undertakings Protection of Employment Regulations, and it's that protection of employment part that's key, and that the regulations seek to do in a number of ways. And as part of TUPE, when a TUPE transfer takes place, employees transfer on their existing terms and conditions. And to make sure that there are no surprises on the transfer and to allow the consultation to run effectively, Regulation 11 of TUPE aims to smooth out that process. So Regulation 11 places an obligation on the outgoing employer, the transferor, to provide certain information about the transferred employees to the incoming employer, the transferee. And I plan to touch on that regulatory obligation in more detail. We will also look at how employee information sharing might operate in practice in a business sale or in an outsourcing situation. And as ever, we'll consider what we need to be mindful of from a GDPR perspective as well. So under Regulation 11 of TUPE, the obligation is on the transferor to provide employee liability information to the transferee to help the transferee understand what they'll inherit in terms of the number of people, the profile of people, just the general basic terms and conditions that they're on. I'm not going to read them all out, but they're on the screen and they're in more detail in Regulation 11 as well. But what you can see is that when you're trying to comply with Regulation 11, it does require a degree of organisation and coordination by the transferor to pull together that information to pass on to the transferee at the appropriate time. You might be able to put it together quite quickly if it's just one employee, but where there are multiple people involved, and often in business cells there can be tens of people, sometimes hundreds, it can present a logistical challenge. And in our experience, some HR teams are very good at capturing that information, particularly where they do a lot of TUPE work. But where TUPE is a less regular occurrence, it can take more time to pull together to make sure you're getting the right information. So if this information isn't readily at HR's fingertips, as soon as you become aware that a TUPE transfer is likely, from a practical perspective, it's worth starting to gather that information if you're the transferor in a business sale, or if you're the transferor because you're outsourcing a service. Or in the case of a retention situation, where employees are employed by a contractor, it's still worth reminding the contractor that they need to pull together that information to be compliant with TUPE. Once you have that information in one place, it will then be easier to update as you go along, so that it's accurate at the time that you need to share it. And what do you do when you've got the information? Well, TUPE says that we've got to give it to the transferee at least 28 days before the transfer takes place and when you expect it to take place. So that's the obligation to provide information under TUPE. As I just said, TUPE requires that the information be sent at least 28 days before the transfer, but there are two particular problems with the requirement. The first is a timing point. So when you start planning your outsourcing or your retendering or your business sales purchases, you tend to do that in most cases many months before the transfer takes place. So if you're looking at a large-scale workforce move or a large-scale retender, then providing the information 28 days before the transfer takes place is going to be too late to help potential bidders understand their costs and their pricing. The second problem with the obligation in Regulation 11 is that it only obliges the transferor to provide limited categories of information. So yes, you get the basic contract terms, but and whether there are any grievances or claims or anything like that. But the employee liability information under Regulation 11 doesn't cover other key things that the transferee might like to know, like whether the employees have any enhanced redundancy protections, and if the transferee is looking to reduce headcounts after the transfer, that type of information is going to be very significant. Also, the employee liability information under TUPE doesn't cover whether the employees have other restrictive covenants in place, doesn't oblige the transferor to share full details about pensions or other administrative information about the employees that ultimately the transferee needs to honour after the transfer. So this shows really that the employee liability information obligation under TUPE is missing what could be quite crucial information, and often it's just too little information provided too late for many deals. And it's also significant for transferees because the transferee needs to be able to identify which measures it will be taking in respect of the transferring employees. And so it's helpful for transferees to have a more comprehensive understanding about the employees that they are inheriting much earlier in the process, so they can identify which measures will be relevant to which employees. And that's why we quite often see the Regulation 11 obligation requirement supplemented by contractual provisions requiring the transferor to provide more information earlier in the process. For instance, the customer in an outsourcing scenario, when they initially agree to a contract in anticipation of an insourcing or retender down the line, will often add in additional provisions requiring the incumbent provider to provide information about employees above and beyond that employee liability information data, just to push out as much information as early as possible. And keep in mind that if you are requesting this information contractually, you should also ensure that your contracts contain warranty from the service providers in relation to the accuracy of any information provided. So we've covered what types of information we might share and in what circumstances. And as we know, when it comes to sharing personal information, the next question that follows very quickly is, what about GDPR? We won't dive into this fully, but I just want to touch on a few brief points that you need to be considering when providing employee information as part of a cheaper transfer. So GDPR doesn't stop us from sharing information in a cheaper situation, but what it does mean is that we've got to focus our minds more on what information is being shared and why we're sharing it. And typically there are 3 scenarios that we'll likely encounter when it comes to the transfer of personal data in this context. So firstly, there's the giving of the employee liability information in line with Regulation 11 of TUPE. From a GDPR perspective, if you're in BLI territory, the position is straightforward because providing this information is a legal requirement under TUPE. So as long as we provide the right information at the right time to the right person, then we've got a lawful basis for providing information under GDPR. The second scenario that we've already discussed is that usually there's either an agreed process or a contractual requirement to provide information that goes beyond the scope of providing information under Regulation 11. On a business sale or outsourcing, it's quite common for that employee information provided many months before the actual transfer date takes place. And that puts us outside the scope of Regulation 11 TUPE. And then in the third scenario, one we haven't mentioned yet, is that when the transfer is about to happen, or when it's just happened, it's common for then detailed payroll or HR information to be passed over to the transferee. And aside from employers providing consent, legitimate interest is the most common basis of processing data in this context. In order to rely on a legitimate interest argument, then we need to look at why we're processing the data and whether it's necessary. And you need to carry out a balancing exercise, balancing the interest between the relevant parties against the interests of the data subject before you decide to disclose that information. Where possible though, and in particular where you're required to share data months in advance of the transfer as part of a contractual requirement, the easier way to comply with GDPR is to anonymise data where possible, as then the information that you're sharing would be personal data. So that covers the information sharing about transferring employees in a nutshell, and I'll hand you over to Rebecca for the next section.
Thank you, Jasmine. So I mentioned earlier that the duty to inform and consult is triggered where the employer envisages taking measures in connection with the transfer. And in this session, we're going to have a closer look at what exactly we mean by measures. So the first thing that I want to say here is that, unhelpfully, there's no definition under TUPE to help us identify what a measure is. And that means that we need to look at case law. And the message that comes out loud and clear from the tribunals is that measures is given a very wide interpretation. In fact, it's going to cover any action, step or arrangement taken in connection with the transfer. And we'll have a look at some of the common measures that we see in a moment. But before we come on to that, I just wanted to say that because measures has such a wide meaning, it's important for an employer to carry out a detailed assessment of current arrangements so that it can identify its potential measures. Now, Jasmine's talked through the process for sharing employee information and the extent of the information that might be provided depending on the nature of the transfer. And that's going to be essential to lay the groundwork for the exercise that the transferee will need to carry out to identify its measures. So once the transferee has that employee information, it needs to review it carefully to identify the measures. And we'd recommend that, as well as looking at the more obvious things like terms and conditions of employment and plans for any redundancy or restructuring, the transferee should also look at things like discretionary benefits and working practices to make sure it identifies anything which will need to change in connection with the transfer. Now, one point to note on that, of course, is that when drawing up measures plans, the employer does need to bear in mind the extent to which TUPE might prohibit it from implementing measures that it would otherwise like to take. So, for example, the transferee can't simply decide that it's going to harmonise terms and conditions because those changes would be void under TUPE. In a moment, I'll run through some of the examples of the common measures that we see. But before I get onto that, there are just 2 points that I wanted to pick up on what is meant by envisaging. So I mentioned on the last slide that an employer must inform and consult about measures which it envisages taking. But what exactly does that mean? Well, This has been considered in case law, and it's held that envisages simply means visualises or foresees. So in short, the employer must have some definitive plan or proposal in mind, and mere hopes or possibilities won't be measures. Now, as I said, we'd always recommend that a transferee carries out a thorough assessment of existing employment terms and discretionary benefits and other working practices to identify its potential measures, so that those measures can then be communicated to the employees. And generally being clear about measures at this stage is likely to lead to a smoother transfer process and also, importantly, better employee relations in the long run. Interestingly, however, I just wanted to note that there's no positive obligation under TUPE for an employer to carry out such an exercise or to take reasonable care to try and identify measures. And that's obviously not to say that a transferee can simply bury its head in the sand, and the employer does have a duty of care not to make misleading statements, but there's no duty to proactively try and identify the measures. So that's an overview of what measures are and also what we mean by envisages. On this slide, there are a couple of other principles that I just wanted to look at, and then we'll move on and we'll have a look at some of the different types of measures that we commonly see. So the first point here is that measures does not include changes which are simply a consequence of the transfer. And that principle comes from the case of Baxter and M&S, where the EAT, so that's the Employment Appeal Tribunal, drew a distinction between measures to be taken as a result of the transfer and those which would be taken anyway. And the background to this case was that M&S had outsourced its profit protection activity to a third-party security provider, which resulted in around 100 members of staff transferring to Securicor under TUPE. And the claim was brought there on the basis that their work was refocused from internal theft to external theft, and that this was a measure which should have been the subject of consultation as part of that transfer. However, the Employment Appeal Tribunal found that the refocusing was actually something that was going to happen regardless of the transfer, and the reason for that was because M&S wanted its arrest rate to go up, so it was something that it was already looking at. Although the timing coincided with the transfer, it wasn't therefore a measure that required consultation under TUPE. And the refocusing there was found to be merely a change of emphasis within the existing job description. And then moving on to the second bullet point, in the same case, the tribunal also found that changes which are inevitable administrative consequences of the transfer are not measures. The point here was that after the transfer, a member of staff was asked to contact M&S's internal profit protection management to determine how to deal with a situation of possible internal theft before they went ahead and took any action. And that was different to how things would have worked before, because beforehand the individual would have dealt with the issue and then informed management. And it was found that the new procedural step for dealing with internal investigations wasn't a measure in connection with the transfer, but what the tribunal called an inevitable administrative consequence of the transfer. So the EAT drew a distinction there between matters of principle, for which consultation was necessary, and how those principles were worked out in practice in particular circumstances after the transfer. And I think that's something that's particularly worth bearing in mind in an outsourcing scenario, or at least an initial outsourcing scenario. And that's because it's often likely to be relevant where the outsourced service is then going to integrate in a new way with the client's functions. And the final point that I wanted to mention on this slide is that there's no detriment test for determining measures. So regardless of whether a change might have a positive impact on the employees, it's still something that needs to be notified. Having said that, obviously, where the transfer will result in positive changes, then the transferee is going to want to give that good news message anyway. But I just wanted to add the note there that it is also a measures obligation. So that's a walk through the key principles regarding measures. On this slide, we're going to have a look at some of the measures that we commonly see. And I've broken them down into 5 categories. So the first category there is changes to terms and conditions of employment. Now, as I said, I'd add a word of caution here because TUPE imposes restrictions on changing terms of employment, which means that changes by reason of the transfer will be void. And so that's an area where advice should be taken if it's something that an employer is looking at. That said, it is an area where we often see employers wanting to make change, and certainly where changes are more administrative, so things like changing the payroll dates or changing the holiday year, then that's something that can generally be achieved with a little bit of caution. The second category then is discretionary benefits. So under TUPE, the new employer inherits the same discretion as the outgoing employer when it comes to making changes to discretionary benefits. And so this is an area where there is more flexibility. Another note of caution, of course, is that the incoming employer might need to consider whether a benefit has become contractual by custom and practice. And it also needs to think about the employee relations aspect. So going in and simply discontinuing any existing discretionary benefits is not really going to get the new employment relationship off to a good start. But it does mean that the new employer certainly has flexibility to replace the outgoing employer's discretionary benefits offering with its own. And the important point to note there is that such a move would still be a measure. So while the transferee inherits the discretion, if it is exercising that discretion and it's doing so because of the transfer, then it's important that it does notify the outgoing employer of its plans. And while we're on the topic of discretionary benefits, it's just worth a note on bonus arrangements. So the starting point with bonus arrangements is to consider the nature of the scheme and the contractual status. But what we often see is discretionary schemes which don't necessarily translate well into the new employer's business. And in that case, it's common for the new employer to replace existing arrangements with its own. But it will often structure the replacement scheme so that it can tell employees that they will have the same earning potential within the new arrangement. And the next category that I've got on the list is working practices. So the sorts of things that I've got in mind here are things like changes to line management, which might be necessary where the new employer is absorbing the transferred workforce into its existing structures. And in that scenario, the impact on the line managers obviously needs to be considered separately to those who are being managed. And it may well be that there are other measures that need to be notified in respect to the managers themselves. The next category that we've got is policies and procedures. So if the transferred workforce is joining an established business, then the likelihood is that the new employer will want to apply its own policies and procedures rather than continuing those of the outgoing employer. And the important point there is to check whether the policies and procedures have contractual status, because if that is the case, then further consideration would need to be given to the risks involved. But assuming for these purposes that the policies and procedures are discretionary, which tends to be the case most often, then the transferee is free to make the change. But again, that's a measure that does need to be notified. And the final category in the list is perhaps the most significant, and that is workforce proposals. So if the new employer envisages any restructuring or redundancy, then that's a measure which must be notified. And it's obviously quite fundamental, which means that more time needs to be factored into the consultation process. It's worth being aware that in certain circumstances, the parties can carry out collective redundancy consultation in advance of the transfer, but we'll keep the detail of that for another session. A final point then on this category is that one thing that we often see is that the new employer envisages that some role changes or redundancies will be necessary as it integrates the transferred workforce. But quite often it needs a period of time to review operations after the transfer to decide on the specifics. And where that's the case, there's then a question as to whether the new employer's plans are sufficiently developed that it envisages measures in that respect. And again, I'd say that that's an area where careful consideration is needed. And there's probably going to be a balancing exercise regarding the obligation to notify measures on the one hand, and the risk of unsettling the workforce on the other hand, particularly at a time where there aren't any concrete plans to share. But something that we do see from time to time is that the new employer will notify its intention to carry out a review following the transfer as being a measure, albeit being clear that any resulting proposals will be subject to full consultation at the appropriate time. So let's look at the broad categories of measures. I'm not going to go through this slide in detail, but it sets out some of the examples of the measures that we see most frequently, many of which we've chatted through on the last slide. And the final point that I did want to talk through in this section is a note on terms and benefits which cannot be replicated by the transferee. So in practice, this is only really going to occur where a benefit is directly linked to the performance of the employing entity. So that's like where there are share schemes or certain types of bonus arrangements. And the leading case on this is Mighty Managed Services and French, which involved a profit share scheme where the employees could receive a payment either in cash or in shares. And the transferee there was simply unable to replicate that arrangement because it couldn't issue the same shares. And the Employment Appeal Tribunal found that instead the employees were entitled to participate in a scheme of substantial equivalence, and that equivalent scheme needed to be free from unjust, absurd or impossible features. Now, we don't have any clear guidance as to what is meant by substantial equivalence. In the strictest sense, that could require that the transferee provides a replacement share scheme, enabling the employees to benefit from an award of shares in the employing entity. Alternatively, taking a softer approach, it could be argued that a replacement component of remuneration, so something like access to a cash bonus scheme, which gives the employees a similar level of earning potential, would fit the bill instead. It's just worth noting there that this case was unusual because the share scheme was contractual. Generally, we'd expect schemes of that nature to be a discretionary benefit. And of course, where that's the case, the new employer then inherits the same discretion to amend or replace the scheme. So it won't always be that this obligation applies. So that's everything that I wanted to say on measures then. I'm going to hand back over to Jasmine now, and she's going to take us through the nuts and bolts of the consultation process.
Thanks, Rebecca. That's right. We've made it to information consultation now. So I put headlines on the slide and we'll delve into them in more detail. So the first thing to understand is that the obligation to inform and consult, they're distinct obligations. So the obligation to inform applies in every TUPE situation where there's a benefit transfer. And when it's anticipated that there's a transfer of employees, employees are required to inform the employee representatives or the employees of the fact that the transfer is happening, and also provide other information as well, which we'll pick up on again later. So that's the duty to inform. Another point on the slide is that the obligation to consult is only mandatory where the employer envisages measures. And even if there are no measures, the obligation to consult and the obligation to consult isn't there under TUPE. Case law still advises us that you should still leave time in the timetable for voluntary consultation to take place. So effectively, that means leaving a gap of time once you're informed before you actually go ahead with the transfer, allowing staff by the representatives to raise questions and make comments on any proposals. In terms of timing for the consultation, generally there's no specified time frame to do this. What's going to be long enough is going to depend on the extent of the measures proposed and the number of employees affected. And even where there are no measures, we'd normally say leaving 2 weeks is sufficient. But where there are minor or medium measures, something like 2 or 3 weeks. But for anything more significant, if we're talking restructuring or redundancy, then we'd expect to see upwards of 1 month and even towards 3. In terms of who you inform and consult, the requirement is usually to consult appropriate representatives of affected staff. But there is a recent exception to this, where it's possible to inform and consult affected staff directly, where the employer is small or where the number of staff transferring is small. But I think the key takeaway is that the duty applies where employees may be affected by the transfer or any measures envisaged in connection with it. And so it's quite obvious that affected staff will include those people who are in scope to transfer in the TUPE, but it can be wider than that, and it can mean that the transferor needs to consult with representatives of employees who aren't in scope to transfer. On the next slide, I put what I see as a breakdown of the information consultation process in 3 stages, or how I would approach it. Firstly, the lead up preparation to the consultation process, then the communications that go out to the affected employees and the appointment of representatives, and then finally consultation itself. And we'll touch upon them all, but as you gather, the theme of today is preparation, and we'll focus on that part as well as the consultation itself. Legally, the majority of the work in this process sits with the transferor, and the transferee's duty when it comes to the information and consultation process is really limited to the obligation to provide details of the measures it proposes. Despite that, it's still helpful when the parties work together to achieve a smooth transfer, and I'll go into that a little bit further again later. When it comes to preparing them, keep in mind always that TUPE requires the employer to consult, so inform and consult the affected employees. So the first part of that is preparing for the TUPE consultation is to identify which employees are going to be affected by the transfer. And in working that out, we need to look at a number of things. So firstly, the identity, functions or services which are going to be subject to the transfer, and the employees who are assigned to that relevant business, so that you can easily identify which employees will be in scope to transfer. With something like an intra-group transfer, that might be relatively easy, because if you're only transferring employees from one subsidiary company to another, but it might be less clear-cut if a business function is being wiped off and sold to another company, and then you have to determine which employees will be in scope to transfer with the business being sold. And also, don't forget to look out for any tricky situations, and consider early on whether you might need to take further advice or undertake further analysis. For example, if there are employees who spend the majority but not all of their time supporting the business that's being subject to the transfer, then you'll need to give extra thought as to whether they are assigned to the business that's transferring. Once you've identified the affected employees, the affected employees who are assigned to the business transferring or the service change, you should also consider whether there are any employees who are affected by the transfer but aren't assigned to the transferring entity. So, for example, there could be central services employees who support the transferring business as a minor part of their role, and although they're not transferring, they may still be affected, and you need to consider the impact of the transfer and what that will have on those employees. For example, in this case, there could be business proposals that might affect them, because they could, if the business in particular is proposing redundancy after the transfer takes place. And that's just a reminder that the obligation to consult covers affected employees and not just employees in scope to transfer. Oh, and as always, I just wanted to mention that it's important that you take care to consider and involve any employees that are absent from the business, for example, due to family leave or to long-term sickness, just to avoid any unnecessary allegations of discrimination when you're carrying out this process. The next preparatory step, which I put on the slide, is to identify measures. And Rebecca's covered how we identify measures. And it's the transferor that needs to identify the measures that it will take in respect of its affected staff. And the transferee also has a role to play, as they must share with the transferor which measures it envisages taking in respect of affected staff as well. You've heard a lot of measures, so we'll leave it there, but I want to turn now to the last preparatory step, which is how you consider how you will approach consultation with the affected employees. So TUPE obliges employers to inform and consult predominantly with appropriate representatives of employees who are affected by the transfer, and there is an exception that will come to it as well. But essentially, if there's a trade union that's recognised in respect to the affected staff, and they're all in the same bargaining unit, then the trade union is the appropriate representative. But if there's no trade union, or there is a trade union, but recognition is only in respect of part of the affected staff, then the employer has a choice for those staff that aren't in the bargaining unit. In that case, they can either consult with staff representatives that are pre-elected, so there might be an existing staff forum, and so for as long as the purpose which that staff forum is elected is wide enough to cover TUPE, and that won't always be the case, then it's an option to consult with them. Alternatively, you can consult, well, you can invite staff to appoint or elect representatives specifically for this TUPE exercise. And this is often a safer option, particularly because you don't need to worry about whether a pre-elected forum is standing or whether individual members are still within their term of office, for example. But if you are inviting staff to carry out an election process, that's going to add some time to the timetable. So that's another thing you need to build in, a bit of time for those elections to be conducted. There are no hard and fast rules about how you appoint the representatives or the number of representatives, so that's just a common sense approach that you need to take depending on the transfer taking place. And you should also keep in mind that if you're consulting with both groups of employees who will be subject to the transfer and also groups of people that are affected by the transfer but not in scope to transfer, then you need to consider how you are pulling together your representatives. And in this scenario, you should consider whether you'll be holding a single consultation meeting with all representatives, or whether you'll hold separate consultation meetings for those representatives of people in scope to transfer and those representatives of people who are affected by the transfer but not transferring. The final point to pick up from this slide that I need to highlight is that there is, as I mentioned a bit earlier, a new exception to the consultation rule effective from recently, January 2024, and that is that if there's no existing worker representative forum, consultation can take place directly with the employees, either if the employer is small, with fewer than 50 employees, or the number of transferring employees is small, so less than 10. So that covers who we consult with. And once you've determined how you're going to consult with representatives or consult with employees directly, then it can be a relatively straightforward process. Send out the initial communications and invite representatives to be appointed. The next slide then, I've just put a high-level steps plan here of how we would normally see the information and consultation process take place. And what you should see from this slide is that several communications go out as part of this process. And ideally, there are several documents that can be prepared ahead of time. That would include the initial briefing to the employees, the invitation for the appointment of employee representatives, the letter setting out the prescribed information that you need to provide to representatives under TUPE. And you can even pull together template Q&As, just so that you're ready to go with that part of the consultation. As we said already, preparation is key. And so having this type of thing ready to go and front-loading the work takes a strain off later down the process. So what information do you actually have to give to the representatives of the affected staff or the employees? The criteria is here on the slide, and the information has to be in writing. So even if you have a town hall meeting, it still needs to be followed up in writing. And there's no specified way that this has to be provided. But essentially, this obligation to inform is to let the affected staff know what's being proposed, why it's being done, and how it's going to affect them. And as you can see on the slide, that includes informing the employees about the measures that are envisaged by the transferor or the transferee. And equally, if no measures are proposed, then that should also be confirmed. Moving on to consultation, the first point on this slide is that consultation needs to take place with a view to reaching an agreement on the measures being taken. And it should be entered into with an open mind. Ultimately, there's no legal requirement for an agreement to be reached on the measures proposed. When do we need to be running this process? We've touched upon this briefly already, but you have to do it long enough before the transfer to allow meaningful consultations to take place, which is quite vague, but essentially you just need to do it long enough or in good time for it to be an effective process. And how long that's going to be is going to depend on the circumstances, in particular how many people are affected, number and the extent of the measures being proposed. And as I said earlier, even if there are no measures proposed and the obligation to consult is applied, then you still should allow time and the timetable for voluntary consultations to take place. And finally, for me, I just wanted to highlight one of the stranger features of GP, which often gets missed or confused, and that is that the obligation to consult about measures is only between the transferor and its own staff, and the transferee and its own staff. So they both have separate obligations towards existing staff who might be affected to inform them and then to consult on those measures. There's a separate obligation on the transferee to comply with the duty to confirm which measures it envisages taking and confirming those measures to the transferor. So the transferor can pass on that information to the appropriate representatives. But there's not actually an obligation on the transferor to consult its employees affected by the transfer about measures proposed by the transferee. And as you can imagine, that leaves a bit of a void, because you could have a group of staff who know that they're transferring to another employer, but don't necessarily have to be consulted on what measures the new employer proposes, which can lead to uncertainty amongst the workforce. What happens in practice, because it's best just to look after employees, is that the transferor will invite the transferee to talk to staff who are going over about what they propose. And for that reason, we often see the transferor allow representatives of the transferee to attend some of the consultation meetings where the measures are being discussed. And as Rebecca touched on earlier, when that happens, really depends on the type of relationship that the transferor and the transferee have, and it's more likely to occur between parties to a transaction on a business sale or initial outsourcing, but a bit less likely to occur on second generation outsourcing, where staff are transferring just between two suppliers. The point that I'd like to take away, though, is that although there is not actually any obligation on the transferor to consult on the transferee's measures, the timeline still needs to allow for voluntary consultations to take place, and transferors will usually either facilitate that process voluntarily or do it because they're required to do it by customer contract or a sale agreement. And on that, I'll hand you back to Rebecca for the final section.
Thanks, Jasmine. So that's the consultation process then. I'm now going to finish with a couple of slides on avoiding liabilities arising from the consultation process. And before we do that, we'll have a quick look at what we're talking about in terms of the potential liability that is to be avoided. So the headline is that the maximum award of compensation is 13 weeks gross pay per employee. So essentially, it's going to be a quarter of the annual salary bill for the affected employees. You might be familiar with the cap on the calculation of a week's pay we see in some areas of employment law, but I just wanted to note that that doesn't apply here. So when we say 13 weeks gross pay, we mean just that. I should say that that's the maximum amount that will be awarded where there's been a complete failure to inform and consult. But the good news is that the tribunal will work backwards from that figure if there's been some consultation. But having said that, the award is intended to be a penalty. So the tribunal is going to focus on the seriousness of the employer's breach rather than the actual loss that has been incurred by the employee. The next point on the slide is also an important one, which is that where the failure to consult relates to obligations on the transferor, the award will be joint and severable, which means that the transfer to the employees. And for that reason, it's usual to see agreement regarding contractual apportionment of liability between the transferor and the transferee. And we're going to come on to have a look at that in just a moment. It's different where the failure arises from the transferee's obligation to notify the transferor of its measures, in which case it's the transferee who will be ordered to pay compensation, provided that the transferor has won an argument that the transferee is responsible. So now that we understand the potential risk, I wanted to finish with a couple of slides looking at how we can avoid it. We learned on the last slide that liability can be joint and several. And what that means in practice is that the employer needs to think about two things when it comes to avoiding liability. So the first thing is how it can minimise the risk of liability arising from its own actions. And then the second thing is how it can protect itself against potential liability from the other party's actions. So this slide has some suggestions in respect to the first category, and it might sound obvious, but the best way to avoid liability is going to be to ensure that the information and consultation process is carried out correctly. And coming back to what I said at the beginning of the session, in practical terms, that means investing time in preparation and planning for the process to make sure that we get it right. Essentially, that means making sure that the process is structured to address all of the things that we've talked about today. So allowing time for sharing of employee information, getting clarity on the measures, and factoring that into the process so that sufficient time is allowed. And also remembering to include time for voluntary consultation where there's no legal obligation to consult under TUPE. Although the consultation process will mainly be a matter for the transferor, where there is a potential for the parties to cooperate, as Jasmine said, that can really help to achieve a smooth transfer process. It's also important for the transferee to do its bit in terms of getting clarity about the measures and share that information at a sufficiently early stage to enable proper planning and consultation. And the final tip that I wanted to share on this slide is to keep a document trail. So at each stage of the process, make sure that there are written briefings, letters and records of each meeting so that we can demonstrate that the necessary steps have been taken. So that's how a party can protect itself against liability from its own actions. And essentially that means by getting things right. Alongside that, we also want to see contractual apportionment of liability, and that's particularly important due to the position that we looked at on joint and several liability. And I've noted on this slide the key contractual terms that we'd usually expect to see. So firstly, we'd expect to see that liability is apportioned by way of reciprocal indemnities, which ensure that the transferor is responsible for any liability which arises from its breach. And on the other hand, the transferee is responsible for liability that arises from its failures. The way in which this position is actually achieved will depend on the type of the transfer. So if it's a one-way transfer, such as where a business is being sold, then that's generally quite straightforward. And in that case, the transfer agreement between the parties will include clauses which mutually apportion liability relating to the consultation process. And in that scenario, the parties to the transfer are the same as the parties to the agreement. So it usually just comes down to a matter of negotiation. The drafting gets a little bit more complicated though, where we're looking at a service provision change scenario. And in that case, there's likely to be an onward transfer when the services agreement comes to an end. So the parties need to agree contractual apportionments for the consultation process, which happens both at the time of entering into the agreement and the consultation process that will happen when the agreement comes to an end. And that means that the agreement needs to cater for effectively a contractual chain of indemnity, making sure that where there's potential for a new service provider to be involved on exit, then the apportionment of liability also covers that party. And finally, there are a couple of other contractual protections which can also help to avoid liability in relation to the process. The first of these is a general obligation for the parties to cooperate to achieve a smooth transfer. And the second is to include clauses providing for the sharing of employee information. So that's all the stuff that Jasmine talked us through at the beginning of this session, and that's going to be particularly relevant where there's an outsourcing agreement, which will involve an onward transfer of staff at the end. So in that scenario, the client is going to want clauses that enable it to obtain adequate employee information to be shared with the new employer. And as we saw in Jasmine's session, that's helpful for the tender process generally, but it will also mean that the new employer has the information that it needs to be able to identify any measures that it has at an early stage of the transfer process. So that's actually everything that I wanted to talk about today then. I'll hand back over to Siobhan now, who's going to wrap things up for us.
So thank you very much to Rebecca, thank you to Jasmine as well, and thank you to you all for joining us today. We hope you found the session useful. Just a quick reminder, we have our on-demand webinars for all of the TUPE Club sessions we do on our website. And there is a particular one you might find helpful, which is one from March last year, which is a back to basics on TUPE more generally, looking at when TUPE applies and what it means. There will also be a questionnaire that pops up at the end of this webinar. We'd really appreciate if you would take some time just to fill in those few questions for us. Our next session is in June, so watch out for the invitation for that. And if in the meantime you've got any TUPE questions, please do not hesitate to contact any of us or anyone else in the team here at Gowling WLG. Thank you and goodbye.